Greetings and welcome to How to Brief a Case, Mastering the Art of Summarization for Legal Success. With that said, this is strictly for the entertainment educational purposes of this broadcast channel here, not to be used misconstrued for anything legal, lawful, professional, personal, tax, financial, or otherwise, so please don't do this at home. That said, let's get started. So, why brief a case? Well, it organizes complex legal information into manageable parts. Anyone can appreciate that. It deepens the understanding of court decisions and legal reasoning. It identifies key principles that can be applied to similar situations and creates memory aids for future reference and analysis. So this is why we brief the case. Organization, deepening understanding, identify the key principles, and creates memory aids. So what is a case? Well, what we're talking about here is appellate case, because the briefs are for the appeals. A review of the trial court's decision by a higher court. The review process examines legal errors, not the factual disputes. So it's a review process only looking at any legal errors that were done in the lower court, not the factual disputes that they litigated. Precedent. Decisions that guide future cases with similar issues. And the legal authority. It creates binding rules for lower courts to follow. So that's what an appellate case is. What is a brief? Well, a case brief, to be specific, is a concise summary of a court's written decision. So what we're just doing here is a concise summary of a court's written decision. That's what a case brief is. It condenses complex legal opinions into key points. It organizes essential elements of the decision, and it captures the court's reasoning and legal principles. It also creates a reference tool for future analysis. Here's some tattered legal materials used in case briefing, which you may have to actually go and look at some pretty tattered books in a law library because not everything is online, contrary to popular belief. Why summarize? Simplifies complexity. It breaks down lengthy opinions into key points. Extracts rules. Identifies the legal principles that can be applied elsewhere. So we're able to extract rules from the case briefs, and it simplifies the complexity of them because, as you see when you're reading the cases, they're rather complex. You break down those lengthy opinions into the key points, and you extract the rules, identifying the legal principles so they can be applied elsewhere. Of course, we want to create those memory aids, providing a quick reference for future use. That retrievability is a big part of this. It saves time. It allows efficient review of important cases and enhances analysis. It helps identify patterns in legal reasoning. So let's look at the different types of briefs there are. There's the classroom briefs. It's a learning tool for students to understand and analyze court decisions. They may use this in their moot courts. There's trial briefs. These are submitted to court to persuade judge on legal issues before trial. And then there's the appellate briefs. These are the formal arguments appealing or defending a lower court's decision. And there's bullet point briefs. Concise format using key points for quick reference and review. So these are the different formats for different purposes. So elements of a brief. Here's our overview. There's going to have a case name, which identifies the parties and the court. The issue, the legal question to be decided, the rule, the legal principle applied, their conclusion of law here, the final outcome of the case. Always have the facts, the legally relevant background, the decision, the court's answer to the issue, the rationale, the court's reasoning process, which is very important to read in their decisions, and the procedure, how case reached this court. So the brief structure, again here, we have the case name in court, the facts, the issue, the decision, the holding, as they call it, that's the court's answer to the issue, the rule of law, the principle applied, the application and rationale, the conclusion, the final outcomes of the case, the procedural basis, the concurring and dissenting opinions. Oh, we missed those down here. Major concurring and dissenting opinions, and the case analysis, the critical evaluation of the case. So as you see here, the structure, it's quite extensive here, but each of them has a purpose. So there's no part here without a purpose. These are the essential components of a comprehensive case brief. So you can see here, facts, issue, decision, rule of law, the application of that rule of law, their conclusion of law, the procedural basis, how they even reach that court, where they get their jurisdiction, etc. The dissenting opinions, which gives you a better insight of how they are able to finally reach that case, but what they were up against, and the case analysis, which would be part of that. Now we have the case name in court. Here's an example here. Brown versus Board of Education, 347 U.S. 483 in 1954. The case name identifies the parties involved. Court determines the level of authority and precedent value. Citation provides location to find the full opinion. And the date helps establish the timeline of legal development. So this is all the parts here of the case citations that you see commonly, how you can break it apart. So this is the location to find and find the full opinion. And you can have page numbers, etc. here too. The date is there in parentheses. It helps establish a timeline. So when you're seeing a bunch of cases cited and you see their timeline within the brief, it helps give context to that. So let's look at the hierarchy of these citations. At the top, the highest authority is the U.S. Supreme Court. Below that is the Federal Appeals Court. These are regional binding. Then there's the state Supreme Courts, which are state binding. These are federal districts, right? Then you have the district trial, which is persuasive only, meaning it's not binding, but it could give guidance at best. But these other ones are binding authorities, especially the U.S. Supreme Court, which is the highest authority. Higher courts create stronger precedent. Now we're on to facts. The facts are the essential background information that led to the legal dispute. Select only legally relevant facts that directly relate to the legal issue. Focus on key details that influence the court's decision. Remember, the focus on the key details is one of the primary things that pay attention to when dealing with these kinds of cases and the facts at hand. There can be many facts, some are irrelevant, some are even immaterial. Best to stick to the key details that are going to influence, the ones that lead to action. Be concise, include only what's necessary to understand the case. None of that superfluous puffery. And present objectively. Avoid personal opinions or interpretations. So here's our fact filter. Parties' relationship, that's a fact. Key events leading to a dispute, yes. Lower court's decision, essential fact. How about irrelevant background details? No, that doesn't get entered in. And personal characteristics, unless relevant, no, those won't come in either. So here we go, the issue. We're on to the issue. The issue is the specific legal question the court must answer. It has to be a clear question, state precisely what the court is deciding, right? This is pretty early up in our list here, as we saw here. We had the case name, the facts, the issue. So out of the case we're briefing, the issue is a specific legal question the court must answer. Clear question. State precisely what the court is deciding. Yes/no format, often phrased to be answered with yes or no. Specific facts include key facts from the case. The single issue, focus on the main legal issue. So here's some issue examples. Does a manufacturer's limited warranty disclaimer violate public policy when a car has a dangerous defect? Another issue, is a search warrant valid when police fail to knock and announce their presence? Can an employer be held liable for harassment by a supervisor when no tangible employment action occurred? Interesting. All these are issues that the court must answer. And each of them are a single issue. You're not combining issues, which is a big problem in the legal realm, because if one fails, the whole question fails. Decision holding. Sometimes a holding, or the court's decision is called. The holding is the court's direct answer to a legal issue presented. It's a clear answer, a direct response to the legal question. It'll have precedent value. It creates a rule for future cases. And it has binding authority. It must be followed by lower courts. And it's a legal principle based on. It establishes rights or obligations. So yes, the manufacturer's warranty disclaimer violates public policy. Or no, the search warrant is invalid when police fail to knock and announce. So these are the ways the decision, the answer, the direct answer to the legal issue is presented. Holdings provide clear answers that become precedent. So see, no, a search warrant is invalid when the police fail to knock and announce. Rule of law. The rule of law is the general legal principle established by the court's decision. General principle, broader than the specific case. So the rule of law is going to be a general, very broad principle. Universal application applies to similar situations. Legal foundation, basis for future decisions. And it's often quoted, frequently cited in later cases. So that's where a rule of law comes in. If it's often quoted, it's a legal foundation, universal application, and a general principles. So here we go. Manufacturers cannot disclaim implied warranties of merchantability for personal vehicles. That would be considered a rule of law. Here's another one. We say a rule of law, not necessarily a law, but a rule of law is a general legal principle established by the court's decision, as a court doesn't create laws. However, this sets up a rule of law for interpreting. So when we say police must knock and announce their presence before executing a search warrant unless exigent circumstances exist, that becomes a rule of law, established principles that guide future cases. Manufacturers cannot disclaim implied warranties of merchantability for personal vehicles. So this becomes a rule of law because of the court's decision. Now that could be overturned with a higher court's decision, of course. That's why it's not a true law. It's got a universal application, but only in similar situation. Application and rationale. Application and rationale explains how the court connects the rule to the facts and why it reached its decision. So it connects rules to facts, shows how the legal principle applies to the specific case. So the court's reasoning explains the logical steps in the decision-making process. Has policy considerations, addresses broader implications and societal impact. And it'll have a key analysis that highlights the most important aspects of the court's thinking. So here's our court's reasoning process. Identifying the facts, select key facts relevant to the legal issue, apply the rule, connect the legal principle to the facts, analyze a precedent, consider how prior cases guide the decision, and explain reasoning, provide logical justification for the outcome. So again, this is explaining how a court connects. That's your nexus here, the rule of law to the facts and why it reached its decision. So the application and rationale, this is where the higher level of reasoning comes in, and you're able to connect all of these different elements together, the reasoning, the policies, and the rules and facts. Well, that takes us to the conclusion portion, not the conclusion of this presentation, but the conclusion of what the court came to in the case we're briefing. The conclusion states the final outcome of the appellate court's decision. Affirmed, the lower court's decision is upheld. Reversed, the lower court's decision is overturned. Remanded, case sent back for further proceedings. Final step, last element of a case brief. So the possible outcomes are affirmed, higher court agrees with the lower court's decision. Reversed, higher court overturns lower court's decision, or remanded, case sent back with instructions for new action with their order. The conclusion determines the final status of the case. So this is really the last element of a case brief. On to the procedural basis. The procedural basis explains how a case reached the appellate court and why it matters. Path to appeal. Shows the journey through the court system. Legal grounds. Identifies the basis for the appeal. Previous decisions. Notes what happened in lower courts. So you see how it lost its way until it got to the appellate court overturned, and it went back or something. So you see the journey from the previous decisions. And the jurisdiction explains why this court can hear the case. So the appeal process goes like this. Trial court, initial decision made, finality. Notice of appeal, formal request for review filed. The appellate court reviews legal errors, not facts. Supreme Court, final review, if accepted. So understanding this path helps determine precedent value. We're on to concurring and dissenting opinions. Alternative perspectives that expand or challenge the majority view. Multiple views. Judges may interpret the law differently. Concurring. Agrees with the outcome, but offers different reasoning. Dissenting. Disagrees with the court's decision. And future value. May become law in later cases. So these are all how the opinions come out. Multiple views. Concurring, dissenting, and then you look at the future value, how this may become law in later cases, or rule of law, we should say here. Types of opinions. Concurring, agrees with the result but provides different legal reasoning. Dissenting, disagrees with the majority's decision and explains why. These are alternative viewpoints to enrich the legal understanding. Okay, so we're on to case analysis. The case analysis involves critical reflection on the case's importance and the broader implications. So the case analysis, we apply critical thinking, evaluate the court's reasoning and logic. The historical context, consider the case in its time period, which when we're bringing up some of those really old cases, there's usually a reason why they haven't been overturned, and that can help strengthen that case. So the broader the impact, assesses effects beyond the immediate parties. So there's, oh gosh, all kinds of things, moral hazard, all kinds of other impacts that might go beyond the direct parties or the immediate parties. Future development, predict how the law may evolve. So analysis framework here, we have legal significance. How does this case change the law? Not really changing the law, but the rule of law. Social impact, who is affected by this decision? Comparison, how does it relate to other cases? And the critique, what are the strengths and weaknesses? So you do a full case analysis, you're looking at all these points, even the weaknesses of it, even the social impact. that might go beyond the immediate parties. Okay, this takes us to the IRAC method. The IRAC is a structured method for legal analysis and case briefing. It's a systematic approach. It organizes legal thinking logically. It's also a learning tool. It helps students understand legal reasoning. And it's a writing framework. It structures legal arguments effectively. It's also an analysis method because it breaks down complex legal problems. So let's look at the IRAC framework here. Start out with the I, the issue. Identify the legal question to be answered. As we said before, the issue was the one that's supposed to be answered with the decision. We have a rule to state the relevant legal principle. So that's our rule, the relevant legal principle. Not the law, but the rule of law. Application. Apply the rule to the specific facts. Then that's, of course, that nexus we spoke about, which is probably the more complicated one of them all and where things either come together or fall apart. And then you have your conclusion. You state the outcome based on the analysis, the application. So the IRAC provides a clear structure for legal analysis. So here's a sample case in brief. Let's take a quick look here. This is Henningsen versus Bloomfield Motors Incorporated from 1960. Facts. Purchased new car with defective steering mechanism causing injury. Manufacturer's warranty, limited remedy to repair parts. So that's our facts. Our issue is, can a manufacturer disclaim implied warranties of merchantability for personal vehicles? Think about this here now. And the way this language is here, it brings that one question. All these parts here about how the person got injured and how they were hoping it was a great steering mechanism because such a reputable car brand doesn't matter. They purchased a new car and it was established they had a defective steering mechanism. And because of that, it caused an injury. Those aren't necessarily facts to be disputed. These are facts just to be mentioned here in the case brief. The manufacturer's warranty, limited remedy to repair parts. So now, can a manufacturer disclaim implied warranties of merchantability for personal vehicles? So the decision was no. The warranty disclaimer was invalid as against public policy. So they can't get through the loophole to get around that social hazard here. And rule. Manufacturers cannot disclaim implied warranties when vehicles are used for ordinary family purposes. Wow. So here's our example disclaimer here. Case brief structure. Application. The court applied implied warranty doctrine to modern automobile sales, noting manufacturer's superior bargaining position. So the court applied the implied warranty doctrine to modern automobile sales, noting manufacturer's superior bargaining position. Where else are you going to go? Rationale. Public policy requires protection of consumers from dangerous products and unequal bargaining power. Conclusion. Judgment for plaintiff establishing that implied warranties cannot be disclaimed in consumer vehicle transactions. So implied warranty, because of public policy, requires protection of consumers. And the significance here is expanded consumer protection laws and influenced product liability doctrine nationwide. Well, I say expanded consumer protection interpretation of laws because it's basically the threat of successful lawsuits based on this precedent. All elements work together to create a complete case analysis. But we can see how just being the bare bones structure and facts, how we can find many ways to apply this structure here in this analysis. All right, that takes us to the closing and takeaways. Case briefing is a valuable skill that enhances legal understanding and analysis. It provides clarity. It transforms complex opinions into clear insights. It allows better recall, creates memorable reference tools for future use. It gives persuasive power. It develops skills for effective legal arguments. And helps with professional growth. It builds a foundation for legal expertise. And as the saying goes, uh, ignorance of the law is inexcusable. And some of us, we all have to be legal experts to some degree. Some may be at a better degree than others and be counselors, but it doesn't prevent or doesn't excuse anyone, I should say, from still being experts in the law. That said, the key takeaways here are: master the elements of a case brief. Apply the IRAC method consistently. Focus on legally relevant facts, not the irrelevant matters. Stay focused. And analyze the broader implications. Again, the societal impacts and public policy. Practice makes perfect. Brief regularly. And we could probably even say that perfect practice makes perfect, actually. So brief properly. And hopefully from this presentation, you'll be able to do such. Autumn says, we forgot this is not legal advice disclaimer. Well, indeed, this is not. This is strictly for the educational entertainment purposes of this YouTube channel and this broadcast. So it should not be used or misconstrued for legal, lawful advice, personal, private, financial, tax, or otherwise. So yes, that disclaimer is out. And please hit the like if you haven't already. So if there is anyone out there interested in how to brief a case in appeals, then this would be hopefully a useful. Howdy there, Shaggy Hippie. Hopefully this will be a useful aid in getting up to speed with how to brief a case and mastering the art of case summarization for legal success. Well, with that said, salute to you all for being here, and I hope to see you all on the next one. Peace out.